7 o'clock. We're going to go ahead and get started now. Good evening. My name is Lisa Spies. I'm the Director of Virginians for Judicial Reform. Our mission is advancing criminal justice reform in the Commonwealth. I would like to welcome and thank you for joining us this evening as we meet and speak with both candidates running for Sussex County Commonwealth's Attorney. I would like to thank both Ms. Hartz and Mr. Robertson for agreeing to participate in this virtual forum. As many of us know, the Commonwealth's Attorney is the Chief Law Enforcement Officer of Sussex County. This is an immensely powerful position that is tasked with seeking justice on behalf of all of those within Sussex County. But what is justice? As we see the country addressing the much needed reform in our criminal justice system, we realize that justice is much more than prosecuting people and putting them in prison. Justice is equal representation under the law. While there is certainly a need for holding criminals accountable by the law, we must also address the systematic issues that have resulted in the disproportionate rate in which poor people and people of color have been treated by the law. A recent poll by the ACLU of Virginia found that 72% of registered voters think the justice system works differently for different people, with economic inequality being the most cited reason, followed by racial inequality. Tonight, you, the voters, will get to hear from both candidates as you make the decision on November 3rd, who you, the voter, believes will uphold the oath to justice, no matter how difficult that may be. Now we'll have both candidates give a brief introduction, starting with Ms. Hartz.
Hi, good evening. I appreciate everybody coming together for this virtual town hall. I'm here tonight because your voice, your vote, and your support matter to me. As most of you should know, if you're attending this event, I'm running for the elected position of Commonwealth's Attorney in Sussex on November 3rd. In November 2019, Lindia Ramsey was the last person we elected for this position, and in April 2020, she became a judge in the General District Court of the 6th District. So now, for the first time in more than 20 years, there are two first-time candidates on the ballot for this very important position. The elected Commonwealth Attorney is vital to keeping your community safe. And if you're looking for the law and order candidate, I'm your choice. And the upcoming special election, you need to get out and vote. I look forward to earning your respect and your vote before November 3rd. And I wanted to let everyone know Sussex has been my home since my birth in 1983. It was home to both my parents and to generations before them since the early 1900s. Today, I'm fortunate to call Wakefield my home with my husband, Jason, and our dog, Seamus. My early education was in Sussex, followed by the opportunities and love of football that I found at Virginia Tech. And after graduating law school, I spent 2 years clerking for the family court in the state of Delaware. I opened my own practice in 2013 and opened a satellite office in Wakefield in August of 2019. I'm a litigator by trade, which means I spend most of my days in front of judges rather than behind a computer. Most of my days are in front of a civil or criminal judge all across the 6th or 12th districts. The 6th district is ours. That spans Sussex, Surrey, Greensville, Emporia, Brunswick, and Hopewell. It's a big area. I litigate divorces, custody matters, and probably the most important thing I do is serve as a guardian ad litem, giving a voice to children of separated families. That's probably the part of my practice of which I'm most proud. I would only close the doors to my very successful practice to serve you guys, to serve the citizens of Sussex County, the farmers, the moms and dads, the God-fearing people, law-abiding citizens, the supporters of our Constitution. My grandfather served in the state Senate. My father served as the mayor of Waverly for 30 years. My grandfather served as the fire chief in Waverly. And now it's my turn to serve Sussex, where the law meets politics. Thanks.
Mr. Robertson.
Thank you. I'm Vincent Robertson, your current Commonwealth's Attorney. And it's my pleasure to be here this evening. And I want to thank Ms. Lisa Spies and the Virginians for Judicial Reform for putting on this event. The virtual town hall, I'm sure that this is the first virtual town hall that involved the candidates in this type of forum. So it's my pleasure to be here. I'm very excited about this opportunity. Also want to thank the people of Sussex County who are participating, as well as others who are participating in this event as well. This is a very important event. This is an opportunity for Sussex County to look at both of the I guess the candidates shoulder to shoulder virtually to do a comparative analysis on the persons with regard to their knowledge, their skills, their abilities, and their experiences. I'll tell you that with respect to my qualifications, I am a Regent grad. I spent 20 years in the United States Marine Corps. I bring virtually almost 40 years of experience to this job. 20 as a United States Marine, almost another 20 as a criminal defense attorney and prosecutor. This is not the role of a guardian ad litem. I have thousands of children that I have represented as guardian ad litems. I have represented people in custody cases. But the most important thing about this job is it's the job of criminal law. And tonight, the people of Sussex County will get an opportunity to determine who is best qualified to be the chief law enforcement officer with regard to criminal law. I look forward to the opportunity. I look forward to the questions, and I'm excited about this, and we'll get to know more about what we've done in this office since we've been here since March of this year, and what we plan on doing going forward. So again, Lisa and the people of Sussex County, thank you, thank you, thank you.
Thank you. Ms. The first question is for you. What does being Sussex County Commonwealth's attorney mean to you?
Well, as Mr. Robertson said, probably the best description of it is you're the chief law enforcement officer. You are actually responsible and accountable to the citizens for not only keeping them safe by prosecuting the crimes that are committed within the county and also within the prisons. As most of you know that if you're listening from Sussex, we have Sussex 1 and Sussex 2 state prisons here. And so any crimes that are committed within the prisons are also the purview of the Commonwealth's attorney, but it is the incumbent on the Commonwealth's attorney to prosecute the crimes that are brought to them generally by the Sheriff's Office, the Virginia State Police, the Waverly Police within our county, and to convene special grand juries for further investigation if that's necessary. But it is your job as the elected, and your subordinates work for you, and it rolls uphill, so to speak. You are the responsible party for the enforcement of the laws as they are written. Whether you personally think it's a good one or not, it is incumbent upon you to enforce those laws. So that's probably the most apt description of it. What it means to me is to be the representative of the people. I'm the voice of the victim, of the general public, and also there's a measure of grace in that. I think that this position, it has the amount of prosecutorial discretion because of the grace that's necessary. It's really the defense attorney's job to bring to the court the mitigation for their client, but they also should bring it to the Commonwealth's attorney ahead of time to see if some of these cases are more apt for diversion or some sort of mental health treatment or some sort of alternative dispositional program. Because like you said, Lisa, at the beginning of this, not every single incident needs to result in punitive jail time. There are other options available to the Commonwealth's attorney. So to me, it means being the voice. And those who know me know that my voice is pretty big and loud. So I think that maybe this is the right spot for me to use it for the good of Sussex County.
Thank you. Mr. Robertson, same question.
This is pivotal time in our history with respect to what is going on throughout our country and indeed across the globe. We're dealing with a global pandemic. We're dealing with riots in the streets. We're dealing with people who are dissatisfied with the government, people who are challenged by fears involved with just their neighbors, as well as the police. People want to know that they are safe in their homes. I spent 20 years as a Marine providing safety for people. And then after that, I spent my career providing for the security and the comforts under the Constitution. That's what's most important to me. I want to ensure that people understand that they are safe here in Sussex County, that the things that are happening throughout the rest of the country, throughout the rest of the Commonwealth, are not happening in Sussex County, and for good reason. You have people in this county who understand what it takes to lead, who knows what it takes to provide that security. I have worked in Sussex 2 prison as an institutional attorney. I have stood shoulder to shoulder with criminal defendants and offenders in cases where they were being prosecuted. I have prosecuted cases. I have handled jury trials. As I stated earlier, I have tried thousands of cases. I understand what it takes to handle this job. I understand the sacrifices that have to be made. There are 120 Commonwealth's attorneys in Virginia. All of them have sacrificed everything to serve in this capacity. Any of them could do anything else and make twice as much money in other areas of law, but they chose this as a profession. Years and years and years of training and experience and cases that we've all have experienced. So this is not just something that you can just come to without any type of experience and think that you can handle the job. So what's most important to me is that Sussex County needs to invest in someone who understands what's going on and has the capacity and the experience to treat everyone equal under the law, and to ensure that they are comfortable in their neighborhoods and everywhere else that they travel throughout this county.
Okay. I'll remind both candidates we're going to try to stick with 2-minute answers.
Okay.
Next question is for Mr. Robertson. It has been said that the cash bail system criminalizes poverty. The citizens of Sussex County would like to know your position on cash bail. Do you support the elimination of cash bail?
You know, I go back and forth with this. I can remember as a criminal defense attorney, when I looked at the different jurisdictions around the country and around the Commonwealth, and I would make arguments to say, Your Honor, there's no need for cash bail. What we should look at is under the statute, what is required to determine whether someone will, 1, is a threat to the community, 2, is a flight risk. Those are 2 of the primary focuses that you have to look at under the statute. There are others that include ties to the community. But when you get into this job and you're holding this seat, you have to look at a number of different things when it comes to ensuring that people will show up in court. In the federal system, what they do is they tie that person to a family member, and that family member is responsible for them getting to court. Here in our Commonwealth, we tie it to money, and not everyone is capable of making a bond. So yeah, there is a disparity between someone who has a considerable amount of money that can make a bond and can get a good attorney, and someone who is indigent and cannot make a bond, cannot afford an attorney. So it's a balancing act, though. I will tell you that you have to look at each case on a case-by-case basis to ensure that the community is protected when it comes to a cash bail or some assurances, some conditions under which the community can be safe if we release someone back to the community, whether it's on house arrest, whether it's with an ankle bracelet, or whatever the case may be. That's the ultimate concern, is the safety of the community when we look at releasing someone, whether it's on with a cash bail or surety or not.
Okay, Ms. Hardy, same question. Do you support the elimination of cash bail?
I don't support the elimination of it, no, because I think that everything has to, if you get into always and never and elimination and absolutes, you get into a dangerous zone, because there are cases where that really is the only surety that someone will show up for court. And you can say, well, you know, isn't it that something that should be taken care of with a show cause or a capias? Sure, but you got to find them, right? And they could be a danger to the community in the interim. So just as Mr. Robertson said, you have to look at ties to the community. You have to look at the severity of the crime. Sometimes there's a presumption against bond entirely. So I can't say that I'm for the elimination of it, but I think that we need to do a better job liaising with Commonwealth's attorneys and defense attorneys to determine these things, number one, before court, to move the court system a little more quickly. There are many pro se defendants that come in and sit in Sussex court from 9 a.m. until 5 p.m. And that just shouldn't happen, right? So it's been a situation, I think, where we could do a better job between the Commonwealth and the defense attorneys. And I'm usually a defense attorney, so I'll tell you from my perspective, I think that we could talk to them more frequently, and the defense attorneys really need to be the ones reaching out, because the Commonwealth has the entire docket to be dealing with every single day. So as defense attorneys, I think that you should reach out to your Commonwealth's attorney and say, is this a situation where you would support bond? Are you requiring a cash bond? Is there something like a scram bracelet we could do? Is there an alternative disposition that we could do pending trial? Because this particular defendant does not have the resources. Yes, there are bail bondsmen and all those things, but that still requires some level of resources. So if I were the Commonwealth's attorney and I had a defense attorney come to me and say, this is my issue, I feel like my gentleman would not be able to bond out, and you would give him a bond, but he can't afford that, then maybe we need to do something a little bit more creative. And there are creative things you can do within the bounds of the law, but still holding true to the Constitution, because that ultimately has to be our guiding document. And that's why always or never or eliminations make me a little bit nervous. I'm more of a let me see case by case scenario.
Okay, that's fair. Ms. Hartz, as
Yes,
as Commonwealth's attorney, you would try major felony cases such as rape and murder. A resident of Sussex County asked, what is your experience trying criminal cases in Virginia courts?
That's an awesome question. And I think that you have to give your shortcomings as when you're running for office as well. Have I ever been a prosecutor? No. Okay. Mr. Robertson rightly so points out that he has the experience because he was named Commonwealth's attorney in April of 2020 when Ms. Ramsey became judge. So yes, he does have that experience. I was not named as Commonwealth's attorney. He was, so he has this experience. But I am a litigator every single day. The criminal code sets forth what the elements of a crime are. A larceny is the taking and carrying away of the personal property of another with the intent to permanently deprive thereof. Did you meet the elements of this crime? Can I prove it? Do I have the evidence that's admissible and relevant to prove it? That is trial work. And that is what I do every single day with a standard much more subjective, the best interest of a child, where people could reasonably disagree on what that subjective standard is. So I have not ever prosecuted a rape case. Should that make you nervous, Sussex? No, it should not, because I'm a litigator and I know the code, I know the law, and I'm very good at trial work, and anyone who has seen me in trials would know that. So Mr. Robertson rightly points out that the experience that he has since he was appointed, yes, he does have that. However, I am absolutely a litigation attorney, and I think that that's what matters when you're trying cases.
Thank you. Mr. Robertson?
I'm a litigator as well. So the thing here is how do you distinguish yourself in a fashion whereas you can show that you are deserving of this role with respect to being able to be qualified for it. I have 5 murder cases that I'm working right now that are on my desk. You want to take over a job where you have no relevant experience, and it's not whether you are a litigator, and it's not whether you are a prosecutor. All of my previous experience in murder cases were as a defense attorney. All of my previous experience in rape cases was as a defense attorney. I also have several rape cases that are on my desk now as Commonwealth attorney. And I lend my experience as a defense attorney to be able to prosecute those rape cases, those murders, those jury trials. So yeah, a litigator? Yeah, I'm a pretty good litigator. I represented Governor Wilder in all of his most recent litigation cases successfully. I have litigated cases against Fortune 500 companies. I have also served as the guardian ad litem. I understand the best interests of the child. I understand all of these things, but when it comes to litigation and prosecution, they are not the same thing. This is most important. There are some very good defense attorneys that are out here, very good defense attorneys. Several of them come to mind right now who would love to have a prosecutor in here that has no relevant criminal law experience. There are defendants that are sitting right across here in the jail that would love to know that there is a prosecutor sitting in this desk that has no criminal law experience. And to be able to think that you can simplify the role of the Commonwealth attorney by just stating the elements of larceny and say, for that reason, vote on me. And this is serious. I have, again, 119 other Commonwealth attorneys that are dealing with all of the different bills that are being handled by the General Assembly today, that are affecting things such as jury trials, affecting things such as sentence credit, good time release, a number of different things that go well beyond just being in the courtroom. And I could go on and on and on in terms of what type of relevant experience you need for this job, but I understand I have 2 minutes. So I'll try to keep my answers. But I'll say this also, though, is that no pro se criminal defendant sits in Sussex County Courthouse from 9 o'clock until 5 o'clock ever. And if someone who practices law, criminal law in this office, you would know that. Thank you.
Okay, Mr. Robinson, the next question is for you. Recently, 11 Commonwealth attorneys in Virginia formed a group to support the restriction of no-knock warrants and increased police reform. Your name wasn't on that list. Do you believe reform is needed regarding no-knock warrants and police reform in Sussex County?
Well, let me tell you this, and this is where my military experience comes in. The most dangerous time in the life of a person, a Marine, entering a building to pull out a terrorist or a bad guy is when they breach that door and go in. The same applies, the same principles apply when you talk about no-knock warrants. Officers have less training than specialized military, Marines, and other services who know how to enter a building and clear it. There are so many examples of that throughout here in recent history in Kentucky, where the officers went into the building, didn't know who was inside, and people ended up dying. No-knock warrants have to be, if you're going to do them, then they certainly have to go through a very strict scrutiny. I don't support them. I'll tell you that when it came down to those 11 attorneys that were representing something I would say would be the far left wing of the groups of Commonwealth's attorney. We weren't invited to participate in that in the first round. There's a number of other attorneys that weren't. They have some good ideas when it comes to no-knock warrants. I think that's one of the good ideas because it not only protects the safety of the occupants in the house, it also protects the safety of the officers entering the house. Because as you saw in the instance in Kentucky, they entered a house where it was a person inside of that house who was armed. And he executed what is referred to as the castle doctrine. And what that is that I have the right to defend my home. What happens is he gets shot and he ends up being looked at as a criminal when in fact he did what any other citizen should be able to do, and that is the right to bear arms and to right to defend my property. And the officers should have been a little bit more judicious about that when it took place. So no, I don't support no-knock warrants in every instance. And I'll tell you, in most instances, I don't support them.
Thank you. Ms. Hartz, same question. Do you believe reform is needed regarding no-knock warrants and police reform in Sussex County?
I'm gonna take those questions separately, if that's okay. I'm I'm a believer in the Constitution. I think we have to always default to our rights as citizens to have our sanctity of our home unless there is reasonable belief and for the search and seizure to take place unless there has been a warrant. So specifically the no-knock warrants, they make me very nervous for many reasons. For one of the reasons that Mr. Robertson stated, but also for the reason of what if you no-knock the wrong house, right? And you come in and guns blazing and all of a sudden you've got a daycare with a bunch of kids in a different apartment. I just think there are situations where that has to happen. I understand that. There are situations where that is warranted, where a no-knock warrant is warranted. And to come back to the same, it's one of those, you have to take it case by case, and to say absolutely not ever can you do that. I think that some of the major takedowns from the FBI would be hindered by that. But are we talking about within Sussex County no-knock warrants? I think our officers are some of the best that I've ever seen in Sussex County. Our police officers have a genuine care for the citizens of Sussex County, and I'm talking about the town, the county, the state police. If you've chosen to work in this rural area, generally you've also taken the time to get to know the citizens. And so I generally don't think that that's as large of a problem here as it is in some other places, because the police take the time to do things safely, and they generally know exactly who lives where because they've been there for a multitude of different reasons, whether it's just goodwill visits or because they happen to live in the neighborhood. So I think in Sussex County, we're doing a far better job than a lot of the big cities where it's just names and numbers. I think our officers take the time to know their community, and I think they should be commended for that. And so I wanted to use the second half of that question to make that point, if that's okay.
I appreciate that. Next question, Ms. Hartz.
Yes,
In
ma'am.
Virginia, there are over 80 different crimes you can commit that will earn you a mandatory minimum sentence. Mandatory minimums are controversial, as a defendant will be punished in a predetermined way, regardless of the circumstances of the crime. A Sussex County citizen asked, what is your position on mandatory minimum sentences?
In general, against. And that's I'm kind of breaking my own rule of saying, you can't take a case by case. In general, on mandatory minimums, against. I think it's done more harm than good. I think it came from a well-founded place to say that some judges were being far too lenient with some criminals where others were being far too harsh. And so there was an effort to be made for some sort of consistency across the board. But I think that on the whole, to take a situation and say, well, this plus this always equals this, leads to a dangerous place. And there's lots of reasons that crimes are committed. Every reason from selfishness and anger and hate to need. Did the woman steal the loaf of bread because she hated the store owner or because she needed to feed her children? Because that matters. Should they get the same sentence? I don't think anybody would say that they should. So what if there's a mandatory minimum for that? I think that creates a system where certain people are punished more severely than they should be, and yet it doesn't allow for the other side of the coin. So I would say on the whole, against, Lisa.
Thank you very much. Mr. Robertson, same question. What is your position on mandatory minimum sentences?
Thank you. I think, first of all, we have to look at the history of what the purpose of the mandatory minimum sentence was, and that is as a deterrent. If you commit a certain type of crime, for instance, felony involving a firearm, you can expect there to be a mandatory minimum that you'll have to serve because of that particular type of crime. Firearms has been one of the use of firearms in Virginia, or particularly in Sussex County, has been one of our chief concerns. Now, the question is, does the defendant know that there is a mandatory minimum when they go out and they use a firearm? If the true purpose of it is to deter the particular act and they have no knowledge of it, then there's no consequence with respect to the actual law. So I don't support mandatory minimums. I think that the judiciary is very mature. They know the law. They know how to apply the law. They should be able to use their judicial discretion when it comes to make a decision about what is the appropriate punishment for this particular crime. Now, with that being said, you also have to take into consideration what the guidelines say. The guidelines in Virginia are advisory on judges. They're not mandatory. They're not required to follow them. So we have to balance that. If you remove the mandatory minimum, you also have to look at what happens on the other side of the law as well. But we're not in support of mandatory minimums. We think that the judges can manage to do their jobs without the General Assembly forcing them to act in certain ways when it comes to certain types of crimes.
Okay, thank you. Mr. Robertson, Virginia is one of 13 states to not have some kind of open discovery law. That is a law that requires prosecutors to give most or everything they have to defendants to allow them to build a case. This is harming people on both sides of the law. Many believe open file discovery can prevent wrongful convictions and improve efficiency in the criminal justice system. Do you support reform in Virginia's discovery laws? Why or why not?
Well, it's a good question, and I think the General Assembly has, well, it wasn't the Virginia Assembly, it was the Supreme Court. The Virginia Supreme Court has answered that question. Rule 3811 has been significantly revised since that question was originally prepared. Just as of July the 1st, Virginia's rules for discovery, which are not a law, it's a rule, is very robust. You have a number of different, it's a sea change with respect to what is discoverable. So it's not just a simple open file now, which has always been the case. A Commonwealth's attorney can always elect to just have an open file. It goes well beyond that. It goes to the point of ensuring that if there's information that the Commonwealth has in its possession that is exculpatory, that it has a duty to pass that to the defendant. That's not a change. But what the change is being able to exchange witness information, to be able to exchange information with regard to all of the other aspects of criminal prosecution, to ensure that there is some balance and there is some fairness with regard to prosecuting a case. The more information from my perspective, the better. I sit down regularly with defense attorneys to go over what is discoverable. I think that it's always better to give more than less, because you don't know what piece of evidence that you don't give up that's going to end up having a reversal effect when the case goes up on appeal. So I'm certainly very aware of what happens with respect to discovery in Virginia. And again, it's not just the open file, it's all information that will consider to be relevant that is not protected under the rule that the Commonwealth should not have to divulge. And she's back.
Excellent. I was starting to panic. I'm glad you're back.
Us too. Yep.
Okay.
That didn't happen.
Ms. Hartz, do you support reform in Virginia's discovery laws? Why or why not?
Yes, I absolutely do. Because here's the issue, and speaking as a defense attorney as well, open file discovery often does not give you the same. Different Commonwealth attorneys' offices view it differently. I'll put it that way. That sometimes the answer that you get from discovery requests is, we have an open file policy, which basically means you can come and you can get it if you want to, and we say that what is in there should be in there. Now, I have not had any discovery requests to Mr. Robertson's office. Let me be very clear. I recently had an experience at a different Commonwealth attorney's office. Can I get the discovery? Yes, we think everything is in there. And that doesn't give the defense attorney a whole bunch of confidence to be able to go back and speak to their client. I think that the civil rules of discovery are much more expansive than just the open file policy. There are more motions to compel. Does that tie up the court process? Yes, it does. But the Supreme Court of the United States has been very clear that all exculpatory evidence needs to be turned over to the defense. And we, as prosecutors, it would be incumbent on us to make sure that that happens, because the citizens only have faith in our system if our system is transparent and if our system works and is fair to the defendant and that they feel assured that the process has been followed. If they feel as though there have been secrets kept, or maybe that file or that portion of the file wasn't given over to their defense attorney, that creates distrust. And that shouldn't be, because it's never the Commonwealth's intent. I have never had a Commonwealth's attorney intentionally, right? The papers, we're getting better with e-discovery, with having everything downloaded and available very quickly, but papers can get shuffled and lost. And I think that there can be a better way to handle that now that we have the technology that we have.
Okay, thank you for your answer. Ms. Hartz, when it comes to first-time youthful offenders, there are many ways to treat the problem without giving the stigma of being a criminal or felon. Restorative justice programs, community service, treatment or skills building programs, and drug courts are just a few. A Sussex County resident asked, as Commonwealth's attorney, would you support mentoring or diversion programs for first-time offenders ages 12 to 20 years old?
Can I get an emphatic yes? Absolutely. As a guardian ad litem, you can be certified in just civil cases, or you can also serve in criminal cases. When juveniles commit crimes, we call it a delinquency, okay? And they can end up being held. Our particular facility is Crater, out on 460. I've visited there many times. It's a very sad place. There are kids there that think that this is just the precursor to where they're going to spend the rest of their lives. They've already resigned themselves to this is going to be my life. It doesn't have to be. There are so many better options. And honestly, I think Sussex on the whole could do a better job at having some youth programs to create the diversion in the first place so that they didn't end up in the courtroom, hopefully. Some after school programs or gym programs would be something that I would love to work with the community on. But as far as once they are in that court system, it is so much better if we can help them then than trying to help them at 25, 35, 45. Once those patterns have been formed and set and they feel that their expectations have been lowered to that degree, if we can intercept these children at 13, 14, 15 and show them, hey, let's do this big brother, big sister program. Let's get interested in the military, in college, in JROTC. And there's some accountability. I actually worked for a drug court in Newport News when I was in law school. They had a great drug court down there. In Delaware, when I worked there, we had a drug court as well. Absolutely, I would support diversion programs for our youth. I think that that's a really great question from whoever posed it, and it should be something that we're all talking about for the future of our country and our county.
Thank you. Mr. Robertson?
Okay, and this is why it's important to have someone in the office that understands what the law is. The youthful offender program has to do with how children who are treated as adults in the courts are housed in prison if they're in prison. They're in segregated sections of the prison so that they aren't intermixing with adults. And they only are transferred over, and it's not just for youth offenders, also for people that are small frames and that are that cannot really cope in a open environment with a mixed environment in the general population. But with respect to how the question was phrased, yeah, it's important that we give children an opportunity to be children. And there are studies that says, particularly with young males, that their brain doesn't develop at the same rate as a young female. You could have a 25-year-old young man, and this is what I learned in my training as a guardian ad litem, who still is acting as an adolescent because his brain hasn't developed yet. And this is what judges are taught. Guardian ad litems are taught. Defense attorneys are taught when it comes to representing children as delinquents. And it's important that you look for different opportunities, different ways, methods to treat children who are juveniles. Now, I will tell you that in my experience as a defense attorney representing juvenile delinquents, there's some pretty bad kids out there. I mean, some really bad ones. course, I can't go into it because I'm still tied to attorney-client privilege in terms of some of the cases. But then you have to go beyond what the situation is with the child and look at the adverse childhood experiences that have developed the child into the way that into where he's at right now, where she is right now. The conditions, the environment, those things that have lended themselves to that person being, quote, a youthful offender. How can you change that dynamic? It's not enough to what I've heard from some judges, and that is, don't do that again, and expect the child to be reintroduced into that same environment, but to do things differently. That's when the role of the prosecutor comes in to work directly with the family. I've done that here in Sussex County as the Commonwealth's attorney. I've done it when I was the assistant Commonwealth attorney years ago here in Sussex County, and I've certainly done it as a defense attorney when I represented juvenile defendants in the thousands of cases that I represented them in. So I have a considerable amount of experience when it comes to representing juveniles, and I understand all the different things that they're involved in. So I'm certainly sympathetic to youthful offenders in that particular term.
Okay. Robertson, to follow up on that question, juvenile justice is currently a hot topic across America. Virginia has one of the highest rates of student referral to law enforcement. This is often called the school to prison pipeline. Sussex County residents would like to know, under what circumstances should a juvenile be treated as an adult by the court?
Well, first of all, a child is not a small adult. A child is going through the same developmental processes that an adult went through to become an adult. So it's important to recognize that, first of all. Secondly, the children that are in that come through Sussex County aren't first of all, there aren't that many. We don't have a very bad juvenile delinquency problem in Sussex County, thank God for that. But there are some that are significant. And we want to identify those, provide treatment for them in whatever way we can, in the most, I guess, the least restrictive way as possible. Because one of the things that I think that is most important is this: when you talk about the prison to pipeline, I mean the prison, the school or to pipeline prison process is it's an important thing to take into consideration, particularly when you look at Virginia. Virginia is one of the states that has the highest rate of incarceration of children. And what happens is that children become institutionalized at a very young age. They become, their environment in terms of being locked up, in terms of being in the courtroom, in front of a judge, desensitizes them to the law. So we have to look at some ways to get them out of that. One of the things I did as a juvenile attorney, a defense attorney, was if I saw a kid that was right there on the edge, he could be pushed over the edge by peer pressure and things like that. I'd take him, I said, Mom, we'll be right back. I'll walk him over to the juvenile detention facility and give him a tour of it and say, this is where you're headed if there isn't a change. Now let's talk about the change. Let's talk about what your plan is. And I'd also, and this is important, I'd also talk to them about where they are and where they came from and how that process started. When was the first time they started to participate in these what we call deviant behaviors? Typically, it starts with the introduction of drugs into their lives. That alcohol or that marijuana is a deviant behavior that creates other deviant behaviors. So if we can attack that problem, make recommendations to a judge, that person goes through a drug treatment program or is tested and things like that, hopefully it'll abate that child from going further into the criminal justice system, and he will avoid prison. Long answer, I know, I'm sorry.
That's all right. Ms. Hartz, under what circumstances should a juvenile be treated as an adult by the courts?
Very limited ones, for a short answer. I believe that there are some crimes that are so heinous that are committed by a child reaching majority, but not yet at majority, where it's clear that the malicious intent and that the child had reasonable knowledge of that malicious intent, that mens rea had actually formed. I think there's a couple layers to that, that it depends on how old the child is, obviously. I don't think there's ever a situation where a 7-year-old should be tried as an adult. But if we're talking about 14, 15, 16, 7, where is that line drawn? I think you have to look at the mens rea, the mental state of that defendant, and also the actus reus, the actual action that child, albeit a child, committed. If it was so adult and so heinous, the court may make that choice that the juvenile justice system cannot properly adjudicate that case. But I think that that is the exception and not the rule. I do think that if there are many reasons for our criminal justice system: deterrence, rehabilitation. And if we're going to pick one of those for juveniles, I'm going to pick rehabilitation every single time, if that's possible. There are some cases where, unfortunately, that's not possible. And so that's where I draw the always never line. But very limited cases, Lisa, I think, is the most succinct answer to your question.
Thank you. Ms. Hartz, in Virginia, the role of determining a punishment after a jury trial rests with the jury. The judge has authority to suspend time or modify a jury sentence to a certain extent, but often courts will impose jury sentences as is. A Sussex County resident asked, if passed, what impact would State Bill 5007 have on the sentencing process in the Commonwealth?
Okay. So if Senate Bill 5007, you said, passes, yes, that the court would be able to modify the jury sentence? Is that the question you're asking me?
What if State Bill 5007 passes, what impact would that have on the sentencing process in the Commonwealth?
Okay, so the sentencing process right now, as you indicated, the jury recommends the sentence. The judge can suspend all or part of it. I actually like that process. I know that there's some controversy about that, but the jury is a jury of your peers, and you ultimately, as a defendant, you have the right to ask for trial by jury or trial by judge, okay? And if you pick trial by jury, then those 12 people have decided what it is they believe. The judge has the ability, as the arbiter of the law, to say that does not fit within the legal parameters, jury. You've made an inappropriate sentencing disposition. But should the judge have the ability to say, oh no, the defendant picked the jury, but I'm going to override the jury's decision in its entirety? I don't think so, because the defendant ultimately had that right of a decision, Lisa. So I think that while I can absolutely see where it could be a jury of your peers comes out with a sentence that you do not believe is quite exactly accurate or does not fit what the judge may have done himself, the defendant took that out of the judge's hands by asking for a trial by his peers. So I think that would be the answer to your question.
Okay, Mr. Robertson, same question. If passed, what impact would State Bill 5007 have on the sentencing process in the Commonwealth?
Let's talk about what 5007 is. It's a Senate bill that's being promoted and sponsored by Senator Morrissey. The purpose of the bill is to give the criminal defendant the election to choose either a jury or a judge to sentence him, okay? Historically, what has happened in Virginia is that prosecutors use the threat of a jury trial over the head of a defendant to force some sort of plea. And why is that? Because of the disparity between a judge and his abilities and the jury and their lack of ability. And what I mean by that is this. The judge can suspend any or all of a sentence. The jury cannot. If a person is given 50 years by a jury, that person has to serve 85% of that time. So they have to roll the dice if they decide they want to go with the jury. It is a deterrent effect on jury trials. So typically, a criminal defendant will not elect a jury unless they just are in a position where they don't have a choice, because they are afraid of what the outcome is for a jury. Now, If they take a jury and they are sentenced, yes, the judge has the opportunity and the option to review that sentence and to overturn it. Historically, in Virginia, judges do not touch a jury sentence because they are considered to be sacrosanct. That's what the jury gave you, that's what you're going to keep. And in most cases, the judge will not lower that sentence. Very rarely will they ever increase it, but they certainly, and it's just as probably as rare that they will lower it. So, but the net effect of this particular bill is that there could possibly be more jury trials in Virginia, because the defendants will say, hey, look, if I get to play the game and have a jury and have the burden of 12 people make a decision about me, but a judge sentenced me, then I got the best of both worlds. But the problem is, when does that person have to elect? What burden does it create for the Commonwealth's attorney? What's the funding mechanism to be able to do that? And here in Sussex County, we have three attorneys. And we have a limited number of defense attorneys. And I don't think Ms. Hartz is on the defense attorney list. I don't think she does any criminal cases here in Sussex. But of those few attorneys who try jury trials, I can tell you from personal experience, I tried a first-degree murder case that took hundreds of hours and over 2 weeks, and I got paid pennies on the dollar to handle that case. Imagine influx of jury trials where a prosecutor will have to take those cases on. There's a simpler answer to it, and I'll make a recommendation for that at the appropriate time instead of the jury trial, because I understand what the intent of the bill is. I've talked to the General Assembly about that personally, and I understand what they're trying to achieve. I just don't think that this jury option, as the bill has been written, is what we need to do for a number of reasons.
About the fiscal impact, and I think the bill also provides the Virginia Criminal Sentencing Commission shall prepare a fiscal impact statement reflecting the operating costs attributable to unnecessary appropriations for any bill that would result in a net decrease in periods of imprisonment in state adult correctional facilities. So I think that's part of it as well.
Yes.
Okay, next question, Mr. Robertson. District attorneys' offices across America are increasingly creating conviction integrity units to re-examine questionable convictions and guard against future error. A Sussex County resident would like to know, what is your position on implementing a conviction integrity review unit in Sussex County?
First of all, it's probably good for everywhere else in the Commonwealth, but here in Sussex, we're good. I'll tell you that my predecessor worked hard on being fair and equitable with all defendants. I have continued in that same vein. I understand that there are other larger jurisdictions that may have that problem where you don't have the Commonwealth's attorney who is directly involved in all of the prosecutions for all of the cases, who's ultimately responsible for what happens. So with respect to the review, I'm not opposed to it. I just don't think that here in Sussex County, it's necessary. There may have been a case for that in the past, but right now under this leadership, we work very hard to ensure that there is transparency. As you are aware that you may not be, you're out of state, but every week we publish the proceedings from all of the criminal cases that we have in circuit court so that the public can see exactly what's happening. That's your review right there, and that's the public who get an opportunity to see that. That's not been done in the past in Sussex County. It was done under my watch here as the Commonwealth's attorney, and we intend on to continue to be transparent when it comes to involvement with the public. What I don't want to see by having a civilian review board is the criminal prosecution become politicized. And we can avoid that just by being transparent. And right now we don't have open courts. So we want to make sure that the people at least have the confidence that the Commonwealth's Attorney's Office is prosecuting cases and that they're getting just sentences. And right now we have a 100% conviction rate on the cases that we've tried since we've been here. And they have been several of them.
Okay, thank you. Ms. Hartz?
Yes, ma'am. I would actually disagree with Mr. Robertson and say that it's needed everywhere. When you rest this kind of power in a few people, whether it's one prosecutor, 3 prosecutors, 15 prosecutors, I don't think there's ever any harm in having someone or some persons responsible to do some level of oversight. Now, do they get to be privy to every single confidential piece of paper? I mean, we could be talking about things that are highly confidential, highly sensitive to people's lives. And so I think that that should be treated very cautiously, because Mr. Robertson and I have to operate under ethical rules. We cannot disclose certain things. And so that needs to be considered when you're talking about any sort of review board, is the confidentiality that is due to the clients and to the victims. But I think that not only transparency, and I encourage everyone to read Mr. Robertson's results. I think that it's very brave of him to put his results in the newspaper and leave them there for everyone to comment on it. It allows the public to give him feedback. So I applaud that he's putting those in the paper. But I do think that there's no harm in having the public know that there's nothing ill going on in your office, whether it's intentional or whether it's just the fact that you have this many cases and 2 maximum security state prisons to be responsible for. I think that it just creates an additional level of public trust. And so as long as there are safeguards in place for confidentiality due to the sensitive nature of some of the things that are handled, then yes, I do support a review board in Sussex and in other places.
Thank you. Okay, last question. Ms. Hartz, the citizens of Sussex County want to know why they should vote for you.
Oh, wow, that one's direct. All right, you leave it open for us. So I wanted to take this opportunity to reference one other bill, if you don't mind, Lisa, Senate Bill 5032. I would like for everybody to take a look at that. Senate Bill 5032 revises assault and battery. If you're convicted of assault and battery on certain persons. Most of us know that if you attack someone because of their gender, because of their race, because of who they are, not just because you have an issue with that person, that there are enhancements for that sort of hate crime, and there should be. Until recently, until the Senate Bill 5032, another protected class were the following: firefighters, volunteers, people responsible for the supervision of inmates, therefore our prison guards, correctional officers, law enforcement officers, judges, magistrates, or any other person involved in the care, treatment, or supervision of inmate or medical personnel. Those people were a protected class that you would get an enhancement if you attacked someone just because they happened to be a firefighter or a law enforcement officer or a jail officer. That's no longer the case. Why is that? If you attack someone because of who they are, it should be an enhancement, and not just because of your religious preference or any outward appearance, but because of who you are and you choose to serve our county, you are no longer a protected class. I found that very scary, and I think that we should all be looking into that. As I stated in my opening, I'm tremendously proud of the practice that I've built over the last 8 years. It was my intention to continue being the voice of children for separated families for at least a decade before I sought this role. But let me be clear, I always wanted to be your Commonwealth's attorney. It was always my intention to use my law degree to help others. It was always my intention to return home to Sussex County and to use the loud voice that God gave me to the benefit of our citizens. Sussex doesn't get the attention that it deserves for the right reasons, and I want to change that. I want our home to continue to be a place where, regardless of our differences, we thrive and we respect each other's points of view. We respect and love our neighbors. We respect and love our police. If this community and our police officers are not united, anarchy will follow. And I am super proud that our police officers are so involved with our community and that that's not an issue here. But I can promise you, under my administration, it would not be. I will require that the community respect and love the police just as the police love and respect the community. Under my administration, I don't care if you're a citizen or a law enforcement officer, everyone will be held to account. There will not be revenge justice, not in our home, because Sussex is better than that. I consider myself a rule of law candidate. I consider myself a law and order candidate. I want to make Sussex a good place for us to love and live and grow with our children. I will not show favoritism, no matter what your creed, color, connection is. I will not ever abandon the Constitution, because that, I think, is our guiding document. And if we stay true to that, we will find the right path. And while you may not agree with me on every single point, I hope that you'll believe that I'll stand on principle, even when that's not the popular thing to do, because pandering politicians create distrust, and our community has the right and the ability to hold me accountable, because I'm one of you, and I've been one of you for 37 years. I want to see all of you once we open up our churches and our community functions. I can't wait to see everybody. I can't wait to earn your respect, your confidence, and your vote on November 3rd. And I ask to be your next Commonwealth's attorney.
Thank you very much. Mr. Robertson?
Yes, thank you again for this opportunity for this this virtual town hall meeting. I'll say that I understand and I appreciate what my challenger brings in terms of her conviction and her passion. But she says that she's been practicing for the last 8 years, but I've never seen her in our criminal courts here in Virginia, in Sussex County, but she wants to be in charge of prosecuting the cases in Sussex County. A vote for my challenger, a person with no criminal law or trial experience, will destroy the confidence in fairness and justice in our criminal courts. It will create chaos within the ranks of the law enforcement, because law enforcement comes to me every day asking questions about this case, how to prepare information about that case. My assistants come to me. They depend on me. They depend on me because I am the shoulders that they lean on, law enforcement, as well as the assistants that are in my office, to be able to guide them in the right direction based on principle, responsibilities, and ethical obligations that we have in this office. Our fine officers depend on the prosecutor not only to prosecute cases, but to also guide them in the process of investigating crimes, to lead them when seeking charges, and to advise them as to the law in preparation and preservation of cases and evidence. The defendants, through their attorneys, will have a field day in the courts in Sussex County, and they will suffer unspeakable horrors because the system of justice will be unbalanced. You'll have defense attorneys running the courts, not the Commonwealth's attorney. It will create uncertainty in the judicial process. And most important, that we have to remember, and that has not been a part of this conversation, is those victims. How will those victims be treated in an office where the Commonwealth's attorney has never dealt directly with a victim of a crime? They will be re-victimized. I have seen so many cases that I've dealt with personally where the victims come to me and say, I wish this would have happened. I wish I'd have known about this. People would talk to me. The Commonwealth's Attorney's Office is a stabilizing force in our system of crime and punishment. The person that holds the responsibility of being the chief law enforcement officer has a tremendous amount of responsibility. I have shown my ability to handle this job. I ask that the people of Sussex County continue me in the role as the chief law enforcement officer in this county. I have shown myself to be credible, to be experienced, and there's absolutely no reason that we've heard tonight to change the course of the way that things are going here in this office with Sussex County. Thank you very much again, Ms. Spies, and I thank all the people from Sussex County for appearing here tonight on this in this virtual town hall.
As we wrap up our time, I would like to thank Ms. Hart and Mr. Robertson for being with us this evening. I think the voters have a better sense of each candidate's views and will be more informed when voting on November 3rd. Thank you to everyone who tuned in to watch with us tonight.
Thank you.
Bye.
Bye. Bye.